With all this talk about ChatGPT changing the way that everything is going to work, I decided to run a little experiment. As a practicing lawyer and a litigator, one of the important roles in my job is to keep up to date with current authorities. In the Australian legal system, there is a concept known as stare decisis. Stare decisis means precedent. What we do is we treat the same situations in the same way. That way, we know what to do when a new situation arises. A big part of that is being up to date with all of the cases that relate to a specific topic. And so I decided to pit two entities against each other. One, a brand new lawyer who's just entered the profession, and two, ChatGPT. Let's see how they go. The question that I posed was this: explain the key principle in the case of Evans and the Queen, and I gave the High Court citation. ChatGPT went straight into action. The key principle in Evans and the Queen is that a court can consider evidence of a defendant's tendency to act in a certain way when determining their guilt in a criminal case. So the evidence must be reliable and relevant to the charges against the defendant. The case involved a man named Mark Evans who was convicted of several counts of offences against his stepdaughter. The prosecution presented evidence of prior acts of sexual misconduct by Evans to show that he had a tendency to engage in such behaviour. Now, there is a case called Evans and the Queen, but it's not the one that I cited. And that authority came several years later. ChatGPT confidently pumped out something to the outsider would seem like a correct answer, but it was totally off the point. It was completely misconceived. I then asked a junior associate who just started with us, who was competent, talented, nice, but very little experience, the exact same question. Please summarize the key principles in this case. Evans and the Queen, 2007 HCA. Evans was on trial for armed robbery at Strathfield Council Chambers. Robbery was filmed on security camera, wearing a balaclava, overall and sunglasses, and he had a list. The key question: was it relevant for the jury to see Evans dressed up walking around saying those words? It could not rationally affect the jury. The fact in issue was the identity of the offender. The separate justices of the High Court said he nailed what was being asked, he nailed what the authority stood for, he nailed what the court actually found, he nailed the principle. This is what a competent, good lawyer, even one with little experience, will be able to separate. And so it's given me some breathing space as a lawyer, because I think that until ChatGPT gets better and is able to properly pass what is being asked, we're going to have these factual errors. And factual errors in areas like law and medicine are fatal. So we've probably got another 6 months before it comes after us too.